Rolling.
Welcome to iEnhance Student. iEnhance Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Mrunal Bende. She is going to deliver a lecture on approach towards crime and punishment in Hindu scriptures on Indian society. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Mrunal to commence with her lecture. Thank you.
Rolling.
Greetings to everybody. I am Mrunal Bende and the topic for the discussion is approach towards crime and punishment in Hindu scriptures on Indian society. Now, in general, almost everybody knows about the kind of punishment that are prevailing in the modern Indian society. But not all are aware about the cruel, inhuman, torturous punishments that were prevailing in the ancient times. Knowledge is not about learning the theories, but training the mind to think why these sort of theories of punishment were prevailing and what was the objective behind these punishments and how the discrimination also were prevailing through the religious interpretation in the ancient time. Now, beginning with the introduction. Man has passed from stages of being uncivilized to being a social being, and there are two main factors for this. One is fear and another is reciprocity. Over the time, man has become more and more social, because of which there has been increase in moral restraint with the interaction in the society. Whenever a man has acted in unrestrained or unsocial manner, there is a conflict with him in the society, because of which rules and regulations have been imposed on him. Earlier, there were no criminal acts or laws to govern the society. People were under constant threat to be attacked at any point of time. The weak, young and the old age people were always easily dominated and suppressed by the powerful and the strong. However, the times have changed. Society has become more integrated with various norms that have come into practices. These violations the violations of any sort of laws or actions which are offensive have resulted in penalties, punishments such as mutilation, banishment, death penalties. But now we have become more advanced with the rise of humanitarian aspect in the penal philosophy, where fines, forfeiture, confiscation of property and imprisonment of life have become a common form of punishment in modern Indian society. Talking about the historical perspective of the punishment of the system. A proverb can be stated, punishment governs all the mankind. Punishment alone preserves them. Punishment wakes when their guards are asleep. A wise can only consider punishment as a perfection of justice. Punishment was basically based on the principle of lex talionis. It is a principle that states a victim or a member of a victim's family can retaliate against the offending party for remedy of personal wrong. That is, eye for an eye or tooth for a tooth. In many instances, personal revenge was not only a right but a responsibility. The Sumerian Code and the Hammurabi Code are the earliest written criminal codes, and these are the harsh translation of the lex talionis principle, which states equality on revenge, which means severity of retaliation must be equal to the severity of the offense, or the amount of retaliation must fit the crime. Now, the mythological perspective of the punishment was that it was believed that in many religions that individual's ultimate punishment is being given by the God, who is the highest authority, who upholds the justice by sending the sinner to the hell. Hell is a place which exists after the person's life, which corresponds to the sin that has been committed in their lifetime. It is said in Mahabharata, punishment preserves dharma, artha and karma. In Hinduism, Garuda Purana is considered as a set of instructions given by Lord Vishnu to the king of bird, Garuda. It deals with astronomy, medicines, grammar, gemstones, etc. It is a medium-sized Purana which consists of 19,000 shlokas. Most of the shlokas states how the offences are defined and what are the prescribed punishment for each of them. And these punishments were the most brutal, barbaric and which were not fit for civil society at all. Some of the punishments are mentioned below. First is kumbhikam. If the wrongdoer destroyed innocent life for food, the sinner, was roasted in hot oil tanks. Sanmali, where it is a punishment which was given when a person committed adultery or there was an unchaste relation between man and women, and the punishment given was tracing by a mace, or also known as flogging by people. The same can be said when stealing others' property was done, including wife, children, and other belonging as well by the wrongdoer. The wrongdoer was traced by a mace. Agni Kunda was one of the most barbaric punishment that was given in that time, which was if a person snatched property by force or gained undue influence or did anything unlawful, the offender was roasted in Agni Kunda in inverted position with hands and legs tied behind on a stick. And Krimi Bhojanam. If a person uses any other person for selfish means or benefits from others' work, the sinner was offered as food to worms, insects, and serpents to be eaten alive. Talking about the Indian jurisprudence under Hindu kings, we can talk about the judicial system, which consists of police, types of court, the kind of proceeding that were taking place, the judges, and the lawyers as well, that are described under the Manusmriti as well as Arthashastra. The first institution considering police, which existed in the pre-Mauryan period. This development of police institution was recorded in Kautilya's Arthashastra. It mentioned that the police during the ancient time was divided into two wings, regular police and the secret police. The police held a conquest on the basis of sudden death as well as involved post-mortem examination and thorough police investigation. Manusmriti also mentioned and prescribed how the soldiers and spies also used to detect the offences and help the king in administration of justice. Now the types of court that were prevailing in the Katyayana Smriti, which is similar to a legal system that established law and distinguish civil and criminal law on one hand and substantive and procedural law on another hand. Now the types of courts that were prevailing in that time were Kula, that is the family council, which consisted of elderly people who were handling the conflicts inside the family and among the family of the similar background. The second is the Shreni. The Shreni were the trade or professional councils. These were the gathering of senior people who were unbiased in their decisions. They had a way of mediating the disputes between the professional traders and artisans. The third is the Gana. The Gana means the village assemblies, who were the huge gathering of the elderly village people, or also known as elders of Grama. And they were also known for their unbiased, knowledgeable and trustworthy decisions. Now, Adhikrita, the court which was appointed by the king, which consisted of people of the town itself who were well versed in Smriti and Vedas. Mudrita was the highest court that can be used by royal seal, and Sasida was the kingdom's highest court in the king's court, which included chief justices and group of judges. And Nripa, the king, who is the supreme authority in judicial system. Yet, he is governed by dharma, which he cannot override. This states, law is the king of kings. Judges were called dharma shastras, and they had the knowledge of law governing court procedures, which were known as vyavaras, and the legislation on all the subject that is known as dharma. And the deep research that they need to had in procedure of rule of evidence was known as Bahushruta and Pramanjana. And they must be a responsible and law-abiding citizens. And the judges in Manusmriti and Arthashastra were mentioned to have qualities such as unbiasedness, trustworthy, not arrogant, not cruel, delightful, kind, etc. Considering the concept of lawyers were called as niyogi in the ancient times, and they generally belonged to the class of Brahmins who were well equipped with the knowledge of Vedas and Dharma. The it also indicated that the lawyers were entitled to collect the pay to extent of 1/16th of the claim suit. Now, talking about the court proceedings, the court proceedings included plaintiff. Plaintiff was also known as Badil. Plaintiff is generally a person who accuses other person of wrongdoing. Then the complainant. Complainant was known as Pratijana, who was a person who was harmed by someone else who filed the complaint in court. Defendant was the person who was known as Pratibadil, who is the accused of the wrongful act, who is known as defendant. Now, the court fees. The concept of court fees, even in the ancient time, was prevailing. The amount of court fees were not fixed on the basis of monetary terms, but on the basis of the lawsuit amount, which the debtor had to pay on 5% of the lawsuit, whereas the plaintiff had to pay the equivalent amount. Now comes the verdict. The verdict is the document of triumph, also known as Jayapatra. It includes simple note of plate, written statement, and the corroboration of both the parties. Through what we have understood, we know that the ancient time was very discriminatory in punishment as well as unequal in the penal system of Indian society. We can have a clear distinction between the people of higher caste and lower caste by imposing the punishment. Taking an example, where a Kshatriya, if he commits adultery with a woman, then he would be punished with the highest punishment. But if Vaishya does the same thing, he would be deprived of his entire property. And if Shudra did the same thing, he was burned alive. Even during the same time, the judge also had a very limited power and he was kept in check. According to Kautilya, a judge or a magistrate who imposed unjust fine had been fined either double the fine or had to pay 8 times over the fine. Also, if he imposes a corporal punishment wrongly, he had to suffer the same punishment. Talking about the forms of punishment that were prevailing under the Hindu code of law. The punishments had an objective that were to create deterrence and retribution. That was to create fear in the mind of people and so that they do not commit the same offense again and again. The type of punishments are capital punishment, corporal punishment, social punishment and financial punishment. We will talk each of them in detail with the types, subtopics involved. The capital punishment means the government has itself sanctioned a practice where a person is put to death by the state for a punishment of a crime. For example, stoning. Stoning is a method of a capital punishment in which a group of people throw stones at a person until he dies. An example can be given. A trench is dug in and the person is made to stand in the trench dug and people surround all around him and throw stones until he dies. And this type of punishment was prevalent in Afghanistan and Saudi Arabia and still is prevalent in some countries in Middle East. The pillory was the sort of capital punishment where offender was compelled to stand in the public place with his hands and head locked in the iron frame so that he couldn't move at all, and then he would be whipped, branded and stoned, or his ears would be nailed to the beam of the pillar. Sometimes even the dangerous criminals were nailed to the wall and they were shot or stoned to death. Undoubtedly, this is one of the most barbaric punishment given in the 19th century as well. Immurent is the punishment where the offender was constructed into the wall, which was one of the most painful death at that point of time, and execution by the elephant. Under this punishment, the offender was thrown under the feet of intoxicated elephant so that he could be crushed with a painful death. Talking about corporal punishment. Corporal punishment is when violation of law takes place, it involves infliction of pain to the body of the offender. This object is again like a retribution, where a person creates a fear in the mind of society through where the repetition of the offense would be reduced. Flogging is one of the concepts of corporal punishment, where beating and whipping with a stick was even recognized by Whipping Act 1864 in India. Then it was repealed in 1909 and it was abolished finally in 1955. The method of logging differed from country to country. Some used whip, some used rubber hose, and some used straps. Again, it was prevailing in the Middle East and is still now prevailing in the Middle East. Mutilation was one of the most worst kind of corporal punishment that was given. If basically it means damaging a person severely by removing any part of his body. For example, if a person lied, his tongue was cut off. If a person was deceitful, his ear were cut off. If a person committed a sexual offense, his private parts were cut off. Hence, in the modern time as well, this sort of mutilation punishment has been completely been disregarded. Now, branding. Branding is shearing of a flesh with a hot iron. The concept was developed through Roman Penal Code, which stated that branding the forehead of the offender with the mark or with the offense that described the offense that he had committed, so that he could be subjected and identified with a ridicule. Then pressured by iron is one of the most worst sort of pain inflicting punishment, where the body of the offender was pressured by 2 iron rods in a very inhuman and cruel manner, where the iron rods were inserted in a manner where, until which his whole body was completely dismembered into 2 parts. Then imprisonment. So generally imprisonment in ancient times were not same as the modern times. Ancient times were different because generally the offenders were shackled or chained by with the hands and legs and were thrown down the well, as well as kept in a dark room. Now, social punishment. Social punishment involved where a person is restrained from making any kind of contact with other person and is moved to a distant place or is kept isolated, and where he is told to break all the social connections. This punishment also stated that no person can help the offender in a manner where he is given support or he is made to come in the caste, or he is considered as a part of the society itself. Otherwise, the same person who is helping out the offender, he would also be liable for the punishment. But the social punishment was different from corporal and other punishment, because social punishment was not inflicting bodily pain but was inflicting psychological pain. The banishment was one of the social punishment which involved expelling the person or transportation to a isolated place, generally known as Kala Pani, if you've heard the term. So, most dangerous criminals were transported to the remote island, and this practice was prevalent during the British Raj as well. But it was abolished in 1955 and it was replaced by imprisonment in life. Then social boycott. Social boycott means an act of forcing a person to abstain from any kind of contact with other people in the society. So this basically punishment was given by Nyaya Panchayat in villages, which said that no person was allowed to have any contact or share any occasion of joy or happiness with the offender. Given an example of stopping a person's hookah pani. Smoking hookah was considered as a social gathering at that point of time. If a person is disregarded from the caste itself, he was not allowed to get into the company of the other people who were in the social gathering of hookah. Hence, also known as stopping of hookah pani. Then finally comes with the financial punishment. It is a basic punishment where the payment of the cost of prosecution as well as compensation to the victim was done. It is a common mode of punishment prevailing today also, but always considering that the financial punishment is given for minor offences rather than serious offences. Then, concept of right to self-defense is an important concept to be known, because right to self-defense was not only prevailing in now times or in the Middle Ages, but also since the ancient time. A term is stated: a person can slay without hesitation an assassination who approaches him with murderous intention. By killing and assassination, the slayer commits no offense. Even killing a Brahmin is in the exercise of self-defense is not an offense at all. A person has a right to oppose and kill, not only in self-defense but also to defend the weak as well as the women in the act of defending themselves. Lastly, concluding, It can be said that in ancient time, the punishments that were given were cruel and barbaric in nature. And Hindu laws, especially the Arthashastras and the Manusmritis, mentioned harsher punishment towards the lower caste people rather than the upper caste people. And more than focusing on the retaliation and restoration of the restoration theories of the punishment, the ancient time focused on retaliation, incapacitation and deterrence theory. The punishment was discriminatory and by handing out stringent punishment to the lower caste, and also the interpretation of various religious interpretation were causing all these concerns. But now, considering that due to religious interpretation, no regards were given to the human life and human rights, through the advent of British rule, theories of law came into existence, and the definition of the punishment and the theories of punishment also started evolving. Like fines, compensation, confiscation of property came into picture and became the most common form of punishment. But later on, finally, the first law commission recommended the criminal code, and in the year 1862, during the British Raj, Indian Penal Code had established, and many amendments also have been made, and many significant changes have also been brought, so that the concept of British Raj, the concept of the Indian Penal Code suits perfectly to the civilized society. And hence, finally concluding, I would like to state a quote by Chanakya. Chanakya had once stated, "Power of the punishment alone, when exercised impartially, in proportion of the guilt, irrespective of the person punished, is the king's son or enemy that protects the world and the next." Thank you so much.